The self-proclaimed prophet, Pastor Paseka Mboro Motsoeneng's bail application has once again been postponed. He appeared at the Palm Ridge Magistrate's Court in Ekurhuleni earlier today. Nqobile Madlala attended the proceedings and joins us now. Nqobile, there were delays in getting things started today, and then the NPA brought a recusal application against the magistrate.
Well, talk about curveballs after curveballs, really. When we started, we heard that the court that we were not supposed to be in because the High Court was about to sit there for another different case for an appeal in that court. Then whilst we waited to hear what was taking place, what was going on, defense already registered their sentiment in saying that they were unhappy with the way their client was being treated. And that's when they were able to speak to the media, talking about the fact that they feel there are discrepancies within the case, and they're saying that they want to bring that to court and they haven't had a chance to, and also citing some safety issues around their person being in prison. And then from there we went on to court, waiting to hear that bail application, only to hear a recusal, which we understand also stems from a conversation, and or rather the utterances that were made by the magistrates within court and outside of court. One of them being the fact that when she was in court, she spoke about the papers, and you'll remember in her judgments last time, she spoke about the issues of the papers not being correct in terms of spelling and so on, and just talking about that there was generally no care being taken in putting forward that affidavits that was brought forward by Mboro, asking, of course, begging for his freedom to go out, saying why he should be given bail. And then now we hear that after court, she then had a conversation just talking about the fact that if the spell check and so on was sorted, then that papers can be brought back to court. Later on, we hear that she then had a conversation also with the prosecutor, talking about the fact that was there something wrong? Why was he being so hard? And this is what was the basis of the recusal. And now I want to bring in the NPA, because of course you are accused of stalling this entire case, and I want to start from there. Are you stalling?
No, we can never do that. We are a respectable institution that abides by the laws and procedures of court proceedings. The availability of the court and everything is not within our power as the NPA. We are controlled by the owners of the building, the Department of Justice, as well as the judiciary in terms of allocating a court. So as much as the defense was frustrated, we were also awaiting to be allocated a court so that the matter can proceed.
And of course the recusal, why bring it forward now?
Well, we hold a reasonable apprehension that the presiding officer will not bring an unbiased mind in adjudicating this matter going further. Hence, we brought the application, and we've substantiated our application, providing evidence, one of them that the accused person appeared before her on the 2nd of September. As a state, we were caught off guard. It came as a surprise. We don't know who requisitioned the accused, and we are of the view that the accused appeared unlawfully before her, and she entertained it. She did not ask, how is it that you are here before me? I know I postponed your matter to October. I see you now before me. Where's the document that states that you must be before me? Because we cannot find that requisition form on the court records. We have instructed the investigating officers to follow it up with correctional services as to how the accused was brought before court. Secondly, also, we've led evidence of the prosecutor. He has indicated and talked about the remarks that were made by the presiding officer to him as an officer of the court, to say, why are you guys so harsh to Motsoeneng? What has he done to you? And we believe that as the state, it's an inappropriate, those are inappropriate remarks, because the presiding officer had and entertained the matter before her. Bail proceedings in their nature, they are an inquisitorial fact-finding mission. She had the opportunity, if she felt that the evidence that was before her was insufficient, she had the powers to call for more evidence, to probe further. And where the state was acting in a way that she's saying that you guys are harsh, she could have made remarks in court to say, but state, I feel that you are being harsh towards Mr. That's the correct procedure, not to make remarks in passing. So we have raised such issues. We are now awaiting her judgment.
And whilst you wait for that judgment, we have heard also from the defense that has said that this is all at the cost of their clients, and they're just concerned that these delays keep having to be paid for by Motsoeneng, mainly because he's paying for his lawyers.
Well, these proceedings were necessary. Remember that the reasonable apprehension that we hold as a state, we needed to ventilate that. We could not let it, we could not sweep it under the carpet. We had to bring it before court so that the court then adjudicates on it, so that we can be able to move to the next step of hearing the bail application itself. So there are these issues that must be dealt with, hence we brought the interlocutory application.
And as the NPA, is there something you can do when a person says that they're unsafe in jail? Because based on what the defense was saying was that the longer this takes, the more unsafe he is in jail, mainly because of the incident where he was brought to court without their knowledge.
Well, we've indicated as the state that it was also without the knowledge of the state, because the proper procedure is that before a person is requisitioned, if they knew that they will be bringing a bail application on new facts, they were supposed to approach the prosecution. The prosecution will then be in contact with the presiding officer to check the availability, be in contact with the Department of Justice and the Judiciary to check the availability of the court to entertain the application, and also check the availability of the investigating officer. Thereafter, ensure that the necessary documents, which is a requisition, is then properly signed by either the control prosecutor or the senior public prosecutor, so that the accused person is then requisitioned to come before court. So we were also surprised as to how the accused person was brought before court, and we are hoping that we will find the necessary answers through the ongoing investigation. And once those answers are received by us, we'll be in a better position to comment.
Thank you very much for speaking to us. That is NPA. They're just speaking about what has transpired, of course, in court. Quite a lot that has come out, especially in that recusal application for the magistrate or presiding officer to recuse themselves, mainly because NPA is saying that they feel that she is not fit at this point to continue with that work, mainly because of what they have put as the basis, as you've heard from NPA. But of course, that remains to be seen. We will hear on Wednesday whether or not she will be continuing with that case, and whether or not then the bail application for Motsoeneng will start. And this is really the concern for defense, that they haven't been able to get their client out to be able to be safer, because they're saying that he's unsafe in jail at this moment.